Good morning.
Good morning. How
Hi,
are we doing today?
Good. Hope you're feeling better, sir.
I am. Thank you for asking. So I'm hoping, unfortunately, there's not a lot of room for error in how we manage our time as faculty. And so when you lose a day due to health issues, getting back the work that you intended to do on that day always presents challenges. Um, so how are we doing today?
Good morning.
Pretty
sir.
good. Glad you're feeling better as well.
Yes, thank you. Thank you. Okay. So, all right. So let's get started. And as we usually do, I want to start by checking in on last week's lectures and making sure that we're sort of all on the same page for what we got out of the out of the lectures last week. So, what do you guys feel like you learned in last week's lectures?
Well, sir, last week we learned about remoteness and the but-for test. And in remoteness, you talked about the 3 questions you have to ask to satisfy remoteness.
Mhm.
And I understand the first one where it asks where the external factors of foreseeable risk of danger. So if the instrument that caused the harm, if you could have foreseen harm from it. But the second question where it asks was the way in which the external factor caused damage, was it foreseeable? And I don't think I quite understand it because there was a case where the manhole was uncovered and the boy fell in and he knocked over the lamp and it caused an explosion. And the court held that he was burned from it, even if they did not foresee, they foresaw burning, but they didn't, even if they didn't foresee the way in which it actually happened, then they were still liable. So how does it satisfy the question? How do you satisfy that question?
Yeah, so I think that my understanding of that case may be a little different than yours, because my understanding is that the court held that the defendant was not liable because the way in which an oil lamp can be expected to harm someone is by burning them, not by causing them to fall into the sewer. And so do we necessarily think that that's a just result? Maybe not, but that is my understanding of the result, is that the court says, look, and so that's where that second inquiry comes from. The other thing you have to keep in mind, right? Those cases.
Hi, I'm not sure, is my Wi-Fi sticking or?
No, it's not only yours.
No, it's not
Oh, okay.
I'm back. I apologize. You know how internet connections are. So all right. So giving this another go. What was the last thing that you heard from your question, Shasya?
You were just about to say the other thing you have to keep in mind.
Okay. So the other thing that you have to keep in mind is that these this 3-part test that we've learned post dates all of the cases that we've talked about. In fact, it postdates Professor Cotellini's most recent edition. It also postdates because it's a 2016 case that this comes from. Because of that, it also postdates the assumption of jurisdiction of the CCJ for certain states in the Caribbean. And it's not clear yet whether the CCJ is going to follow the lead of the House of Lords. So this is one thing that sort of presents a puzzle for lawyers in the region, is how do we know whether the precedent that we draw on from London is going to be followed by the local Caribbean institutions where they are the ones that we have to follow. So the effort by the court in devising this three-part test is to make sense of the cases that came before that didn't necessarily make sense if you look at them sort of holistically. Okay.
So, sir, so like for exams, we will look at these 3 questions, but also look at cases after to like give the other side or what might happen.
So the answer to that is my exams will be built to test you on the doctrine that I have taught you. Okay. What I am doing by sort of mentioning this is I want to flag for you that in practice, right, when you are out dealing with clients, determining what the doctrine is will not just be a matter of turning back to your notes from this class and going, well, what did Dr. Krell teach us, right? There's going to be more involved where you're going to have to figure out what applies in your given jurisdiction. So does that help you sort of understand
Yes, sir.
why I'm talking about this, right? This conversation is not necessarily about exams. This conversation is about the next 25 to 30 years of your career.
Understood. Thanks.
So, okay. What other questions do you guys have about remoteness?
I don't think I have any more.
Okay, great. Anybody else?
Sir, in regards to the midterm, how would you know? Because I see at the end of the email, you like maybe the time would suggest that you haven't given. If people fail, the time would suggest. How is that gonna work? Like, you're gonna wait until the time doesn't suggest, or you're gonna just.
So if when I get the midterms back, no one has answered past question 15, or very few people have answered past question 15, that's going to be a pretty strong signal to me that the exam was longer than the time permitted that would allow, right? And so that's really what.
So, and what would happen? You would retake or you would just improve on the final exam.
I would just throw out the questions that no one got to.
Okay.
Yeah.
Thank you.
Yeah, no problem. So the
Excuse me, sir.
Yes, go ahead, Pamela.
Sorry, I came in late, so I'm a bit lost. The midterms will be multiple choice or something like that.
So the midterm is a short answer. However, I don't necessarily think that. I think that when you are testing sort of some higher level analysis skills, that short answer questions very frequently don't give students enough guidance to sort of give them the right the path to the right answer, or at least it can be very difficult for them to do so. So the questions will be presented as multiple choice questions. But you will need to provide a sentence or two that explains why the answer you chose is correct. And the other piece of this is, if you pick the right answer, you get full marks regardless of what your explanation is. If you pick the wrong answer, but your explanation makes sense, you can still get some marks. So it's an opportunity to sort of pick up some additional marks along the way. So does that?
So
There is an email that addresses the format of the midterm. We do not want to spend all of our time in this tutorial answering questions about the format of the exam. So if you have other questions after you review the email, please feel free to email them to me and I will communicate answers to the entire class. Okay, I don't want to waste all of our time in this tutorial discussing administrative matters. Okay, those things are important, but they need to be dealt with in the forum where it is appropriate for them to be dealt with. So I have a private question, just asking for an overview of the remoteness stuff, right? So one of the things that I think has been helpful this week in tutorials in sort of clarifying remoteness for a lot of students is to think about it like this, right? Causation and remoteness are very entangled, and it is easy to be confused about them. And if you are confused, I want you to know that you are not alone. And certainly I was confused about the difference between causation and remoteness, depending on the, because my readings didn't necessarily make a whole lot of sense of it either. Here is what I have found that has been helpful to students this week. Causation is backward looking from the plaintiff's injury. Okay, so we are asking, for example, right, let's look at the facts of the Palsgraf case that we talked about last week. Mrs. Palsgraf was injured by scales falling off the wall of the train station. Well, why did the scales fall off the wall? They fell off the wall because of the shock wave from the explosion. Why was there an explosion? Because the passenger at the other end of the platform dropped his package of fireworks. Why did he drop his package of fireworks? Because the railway agent was pulling him onto the train. Okay, so we're able to start from the injury to the plaintiff, and we're able to work backwards to the defendant's negligence. And that's the causation analysis. Joy, thank you for answering that question. Okay. Remoteness is a forward-looking analysis from the perspective of the defendant's negligence. So again, looking at the Palsgraf case, right? The train guard is pulling the passenger onto the train, and assuming that he should have known that the passenger had fireworks, right? Because that's sort of resolved at this point in the analysis because the question of breach has already been answered. So he should know that this is a possibility. Would he foresee that Mrs. Palsgraf could be in the way of danger from the package of fireworks? And Justice Andrews says, well, yes, because the duty of care is the duty to prevent the explosion, and everything that's caused by the explosion is encompassed within the remoteness analysis. And Justice Cardozo says, well, no, right? There's this bubble of harm, of people who could reasonably be harmed by the package of fireworks. And if you're outside the bubble, the fact that there's a series of events that leads to you being harmed does not impose liability on the defendant. Okay, so
Sir, can you just repeat that last thing you said?
sure. Just if you are outside the bubble, right, whatever that is, however that's defined in a given case, if you're outside the bubble of foreseeability, the fact that there's a chain of events that leads to your harm does not impose liability. Okay, and again, this is Justice Cardozo's position. I want to emphasize for you guys that Justice Cardozo's position is not accepted anywhere in the Commonwealth that I'm aware of. And I looked, okay? So throughout the Caribbean, Canada, the United Kingdom, India, South Africa, everywhere that I know of where the common law writ runs, except in some of the United States, Justice Cardozo's position is not good law. Doesn't mean you can't argue it as an alternative, but it is not good law. Okay? So, to the person who asked me this privately, do you feel like you maybe have a better grip on remoteness now?
Sir, I would just ask one question.
Sure, go ahead.
So would you say that remoteness takes some of the liability from the defendant rather than put more of the liability on them?
Absolutely, right? But for causation just asks, can we trace back through, from effect to cause back to the defendant's negligence? And it doesn't ask questions about, sort of how many links in the chain there are or what sorts of other issues may have arisen, right? It just asks, can we make that link? Remoteness says, even if we can make the link, there comes a point where we say it is not reasonable to impose liability on the defendant. Okay, so does that help?
So we say then that the chain of events that happened after that person's act has taken the liability from them because it was too remote.
I would say that the right way to phrase that is to say that that a reasonable person in the defendant's position would not have foreseen the harm that the plaintiff suffered, and so would not have known to take precautions against it, right? Because we can't expect defendants to take precautions or to take care to prevent harm that they can't foresee.
Understood.
So does that,
Thank you.
okay,
Yeah.
does that help?
Yeah, thanks.
Good. Okay,
Sir,
yes, go ahead.
I feel like you're just saying that you can't expect the defendant to do something to avoid harm that they can't foresee. But you said we can't. Justice Cardozo's thing isn't applied anywhere, which means we're looking at the other perspective in that as long, it depends on the extent of the harm that can happen from the actions.
Mhm.
And which means, I don't know, it seems as though anything can happen. And as long as it's a direct, I don't know if to say it's a direct result, but if you can't foresee it, but it's part of the extent that it could happen, I don't know.
Well, let's extend the Paul's graph fact pattern, right? And let's say that there's a different some additional facts that maybe there's some things that might change our analysis under the foreseeable harm, right? So let's say that when Mrs. Paulsgraf gets struck by the scales, that she's concussed, right? And because of the concussion, she is unable to take proper advice, and she loses a bunch of money in the stock market. And she comes back and she goes, well, you know, Long Island Railway, you're responsible for my diminished mental capacity. You're responsible for my bad investments. Pay me back my losses, right? We can trace a causal chain back to the railway guard's negligence, but it would be absolutely unreasonable for the railway to have foreseen that that harm could result from that act of negligence.
Okay, I think I understand. It somewhat sounds like, I don't know if you had explained a case of I in text, but where this lady, the doctor had misdiagnosed her or something,
Mhm.
and she, what did she do? I think they settled, you said they settled for a lower price.
Yep.
So they couldn't foresee that. That's not the actual harm they would have thought. It's somewhat similar. I think I understand now.
It's very similar, right? And this is the third element of the foreseeable harm analysis that we learned, right? The question of, is this the type of harm that you would foresee? And this is why I'm talking about, you know, courts who want to take a broad approach analysis just ask about, you know, sort of the headings of damage, right? The damage to property, damage to person, economic damage. Whereas courts that want to narrow the availability of recovery may look for more precise definitions of what the foreseeable harm would be. And so they might say, okay, something falling on your head might, you know, we might expect a concussion. We wouldn't expect you to trip and fall and break your ankle. Okay, and so that would be a situation where a court could read the foreseeable harm narrowly. So does that help?
Yes, sir. Thanks.
Great. Okay. Have a question about defenses, and the answer is we're not going to cover that today. We will cover that in a later tutorial. And certainly when we have our revision session before the midterm, if you are not confident about that, we can touch on it then. Another question in the private chat: if the defendant cannot foresee the injuries suffered by the plaintiff, then the damage is considered remote. Yes, that's basically it, right? The rest of what we've been doing in talking about this is figuring out how the court draws that boundary and how it says this is the point where the harm becomes too remote. Okay?
So you can repeat that, the message that was sent to you.
Sure. If the defendant cannot foresee the injuries suffered by the plaintiff, then the damage is considered remote. And here I will actually copy and paste this into the chat for those who are more text oriented. So, oh, no, I sent that I hit the wrong button, sent it to the wrong person. Hang on 1 second. There it is. All right. So, do we feel okay about this, about remoteness as it is?
Yes, sir.
Okay. That didn't sound especially confident, but if you want
I think
to,
I'm good for now.
okay. So, all right, then let's move on. Go ahead, Erica. You came off mute, but did you have something you wanted to ask? No? Okay. Oh, okay, got it. All right. So today's activity is to describe for a client how causation is established in cases of negligence. So, I will give you guys sort of the option at this point. If you have had an opportunity to prepare an answer for this, we can go ahead and get started. And what we're going to do is just work through what you guys have prepared. If you need a couple of minutes to gather your thoughts, then we can take a couple of minutes, and that's up to you, whichever you prefer.
I wrote down something up to kind of like remoteness of damage, but I don't know if it's fully complete.
Well, let's hear it, or put it in the chat, or whatever works for you.
Let me read it.
Okay.
So, oh wait. So I think I should you explain to them what's negligence first?
Well, I think the answer to that is that, that is not the call of the question.
Okay.
But what I will say is, if you feel like that's a necessary component of the explanation, you should feel free to include it. So things like that, where something is not necessarily responsive to the question, but it may be a necessary preliminary step, you should feel free to include those, but they should not be the focus of your answer, right? So if I were to ask you this question on an exam, and your response was only to talk about what a duty of care was and how we know whether that duty's been breached, you would get some marks because what you would say would be correct, but there would be no way that you would get anywhere close to full marks because you weren't responsive to the call of the question.
Okay, understood. So I would tell the client that you can only recover damages if you can trace the harm back to the defendant. Causation shows whether the breach of duty was the immediate cause of harm, whether your actions were sufficiently related to the injuries that the law will consider you to have caused the injuries, so as long as your actions have been found to play an operating cause in the harm that justifies liability. So there are two elements to causation that must be proved. Those are causation in fact, which is done through the but-for test, and the second element would be remoteness of damage in law. So firstly, because you have to prove that the defendant's breach of duty was actually a cause of damage, the but-for test, you have to prove that the harm would not have happened but for the defendant's actions. And I could tell them, for example, the case of Barnett and Chelsea, and the Kensington Hospital Management, where the victim went to the hospital complaining for nausea after drinking tea at work. The nurse called for the on-call doctor, who refused and told the nurse to tell the victim to contact his GP in the morning and if he still felt sick. So the victim died 5 hours later from arsenic poisoning. But when the wife sued the hospital, the court said that even if the doctor had seen Mr. Barnett, he would not have been able to prevent his death. So even though the doctor was actually negligent, his failure to examine the victim did not in any way cause the death, because it was found that the antidote wasn't available, and by the time he came, it would have been too late.
Yeah.
So then I would go on to talk about remoteness of damage, which asks whether the loss of damage was a type that was reasonably foreseeable to be the likely result from the breach of duty. And the test for that comes out of the Wangamon number 1, which says that a defendant will only be liable if it was reasonable to foresee the type, kind, or class of damage that in fact happened. In other words, whether or not the damage was reasonably foreseeable. And I could give an example of a case where, didn't include that. But I also have that you don't have to foresee the precise extent of the damage but the general type suffered by the claimant. Yeah, I'll just leave it at that.
Okay. So let me start by saying everything that you said is absolutely correct.
Okay.
If I were your client, I would be completely lost.
Okay.
Here's why, right? You have to keep in mind, and this is no joke. This is one of the hardest parts of being a lawyer, especially of being like a personal injury lawyer, is your clients are very frequently quite unsophisticated. If they're lucky, their meeting with you is the first time in their lives that they've ever interacted with the legal system, right? They may have some sort of criminal record as well, whatever, we're not discussing that, but they're not going to be people who are repeat players in the system, know the ins and outs, understand the jargon, okay? What you prepared, Shasya, is an excellent explanation of causation for the bench, right? For you to sort of prepare for your submissions to the court, right? But you got to really break it down and make it simple for clients.
Okay.
And this is so hard. And I don't want you to, I don't want any of you to feel discouraged that you're not getting it on the first try. Okay? Because this is one of the hardest things that you will do in the practice, is explaining to your client in a way that they can understand how their case is going to be handled and how it's going to be evaluated and how you evaluate it, right? So some things that I would encourage you to do, right? Number one, jargon is okay, right? Clients can understand jargon, but you have to explain it to them, okay? So for example, if you say we're interested in whether the breach of the duty of care caused your injuries, okay? You should say the breach of the duty of care just means that the thing the defendant did that they shouldn't have done, right? Or the thing that they should have done that they didn't do, if that's what the facts suggest. You did really well when you were talking about the Barnett case, right? Concrete examples are really helpful for clients. But they don't need to know case names. You can just say, okay, you can phrase it as a hypothetical, right? So suppose that someone went to see their doctor, went to see an emergency physician, and the emergency physician said, oh, you're fine. Just go see your general practitioner if you're still not feeling well in the morning. And then the patient dies. Right? So far it seems like the emergency physician is on the hook. But if the patient was going to die, whether the emergency physician examined them or not, then the physician's actions did not cause the death. Right? So that's sort of my my suggestions, but I think that this, I think again, it's very clear that you understood the doctrine, and that was very well done. The piece that was missing was making it appropriate for an unsophisticated audience.
Okay,
And it may be, yeah.
Oh, I was just saying that made sense, because when we first started law, we would have had to know what was breach of duty. Like it would not have been clear like that. So makes sense.
And one of the things that I think is difficult for students to understand is that you guys are actually quite sophisticated at this point in your educations and careers. You know, you guys have learned a lot, you know a lot about law, even if you don't necessarily feel like it. And there's thousands of people on this island, on whatever island you're living on, who don't even know as much as you do. And they have legal problems too, and they need attorneys as well. And it's really important for those attorneys to be able to explain the legal system to them in ways that they can understand. Okay, so Zania, you've been very patient with your hand up. Go ahead.
Sir, I have a question. I'm not sure if it's relevant or not, but in an exam, would you answer a scenario-based question like you are explaining something to a client or like you are before a judge?
I think it depends on the call of the question, right? So there will be questions that will call upon you to advise a client. And sometimes the facts will indicate that the client is quite sophisticated, right? So for example, last semester when I taught real property, one of the questions that students were called upon to answer involved advising a bank. Well, a bank is a very sophisticated high-end client that you'll probably be talking to another lawyer, right? You would be advising the in-house counsel, or you'll be advising someone who's, you know, if you're in-house counsel, you'll be advising someone who's a very, you know, a sophisticated participant in the business. In torts cases, you know, involving personal injury issues, it's very likely that your clients will not be as sophisticated. And so you need to sort of be sensitive to what you're being told about the client in order to know whether, you know, how to calibrate your, the level at which you give your advice. And that can be quite difficult, right? But it is a necessary skill, right? To sort of be able to read the room a little bit. So does that answer your question, Zania?
Yes, it does. Thank you.
Great. Would anyone like to go next? Someone's posting in the chat. Let me scroll up and see. So Erica's posted her answer in the chat just because of some mic difficulties, and that's fine. Causation is the link that ties the defendant's act to the claimant's loss. For negligence to occur, the defendant must owe a duty of care to the claimant. The defendant must breach that duty of care, and damage must be a result of the lack of care. There are 3 tests for negligence, which were established in the Caparo case, where there is foreseeability. That is, if the defendant foresaw the outcome. Secondly, there is proximity. This is the closeness between parties and whether it is just, fair, and reasonable to impose such a duty. So a couple of things. First of all, right, there's the general, this is at far too high a level for an unsophisticated client. But there's also some issues with the content, right? So we remember that the Caparo case is about whether a duty of care exists. It's not about causation. And so if in talking about causation, you're talking about Caparo, there's something missing from your analysis. The other thing is that we have to remember that at least in London, where the Caparo test comes from, Caparo is no longer good law, right? The Robinson case is the most recent statement of the test for the duty of care. Now, I do think that you are correct that Caribbean courts are divided on whether or not they still use caparo. Certainly the jurisdictions that look to London will have adopted the Robinson test. CCJ jurisdictions like Barbados are harder questions, right? So we may not get an answer to whether the Robinson test or the caparo test is the appropriate one for quite some time. But this is, so Erica, what you've given us is a very nice explanation of the test for the duty of care. So there would be some marks for this. Where things would sort of fall short for you is that's not what the question called for, and it's at too high a level for the unsophisticated client. Okay. But very, very nice effort. I really appreciate that. All right. One more, then I'll give you sort of what I would do in this situation, and then we'll wrap up. So who would like to go next? Erica, I appreciate that, but I would like to hear from as many students as possible. So you're welcome to email me another attempt, and I'll send you back my thoughts. Okay. So who would like to go next? Someone who hasn't gone. Nobody? If nobody wants to go, I'll give Erica another bite at the apple. So Erica, take it away. Go ahead. Presumably we're waiting for you to put it in the chat, and that's fine. So while you're doing that, I will give you guys what my answer would be, right? Here's what my answer would be. And this is specifically for the client. I would say causation is about whether we can blame the defendant for your harm. So let's say, for example, that I'm at a cricket match, watching the match, and I get distracted and I'm looking away from the match, and then something exciting happens on the oval, and everyone around me stands up and cheers, and I sort of get brought back to the oval, and then I stand up. Well, why did I stand up? I don't know what's going on. I stood up because everyone around me stood up. Why did they stand up? They stood up because there was something exciting that happened on the oval, right? Don't ask me what it was that was exciting that happened, because I know nothing about cricket. And so the ultimate, the cause of me getting out of my seat is the exciting thing that happened on the cricket oval, even though I know nothing about what it was. Okay? That's how I would explain causation to an unsophisticated client. Okay? So have a private message for this. Let me just check in with this person. Is this the whole answer, or is there more coming? Okay. we'll wait for the little more then. So while we're waiting, what questions do you guys have before we wrap this up?
I don't have any.
Okay. Anybody else? Nothing else? Okay. So let me know when you are done, just to make sure. Well, we're not going to. Okay. So this private message says, before establishing causation, we must first look to see if there is a duty of care owed to you, if that duty was breached, and thirdly, if the breach was the cause for your damages. So is he, being the defendant, the reason for your injury? Was he negligent? Further explain what negligence means legally, right? And because that's not the call of the question, right, we'll just sort of slide on by. My concern here is that this is a perfectly nice explanation of sort of what negligence is, right? How we sort of analyze negligence as a whole, but it doesn't get into the details of this is how we talk about causation, right? So, very nice, sort of explanation of that. Little heavy on the jargon, right? So I would encourage you to think about what are the things that are legal terms that would need to be explained to a client. Okay, right? So just off the top of my head, right? If I were the client, I would be saying, what's a duty of care? Right? And sometimes, particularly unsophisticated clients may not even know like the normal, the everyday definition of terms like breach. So those may be things that require explanation as well. Go ahead, Renice, you've had your hand raised. Go ahead.
So I'm just asking, is that what you just explained with the oval and a cricket? That's the full explanation of the question that we had to answer, or that was just part?
I think that it would be. I think that it would be appropriate to then tie that to the facts that the client had told me. But in terms of how do we talk about causation, right, without sort of attaching it to any sort of specific case that I'm analyzing, that's a complete answer, right? And it's pitched in terms that that a client who doesn't necessarily know much about the law will be able to understand, right? So, so last thing, and then we'll go. I have a private message here, and I just rather than read it out for you guys, I just will say to the person who wrote it and to all of you that your clients don't care about the cases. If you are speaking to a client, mentioning case names is just going to turn off their brains. it's okay to talk about the facts of the case. And certainly like on an exam, if you refer to the facts of a case, you should drop a footnote so that, you know, I as the examiner know where you're drawing this from. But when you're talking to a client, the case name is just going to absolutely turn them off. They're going to stop listening. So, so that would be my best advice to all of you when you're speaking to clients about these kinds of things. Okay. So, all right, we are out of time, but I really appreciate all of the effort today. This is a hard task, and so you guys did a really good job, and I really appreciate that. And I hope you understand that, you know, my comments aren't intended to suggest that you're falling, that you aren't working on this and aren't getting better. It's to suggest that, hey, you're still in the process of learning, and here's some things that you need to be working on, right? Okay. So great job, guys. I will see you guys next week. All right. Take care and bye.